All right, welcome to this explainer. Today we're going to tackle something that usually strikes fear into the hearts of law students, contract law. But we're going to conquer this overwhelming mountain using some seriously simple, yet incredibly effective memory cheat codes. If you've ever felt, totally lost in a sea of dense legal terminology, you are in exactly the right place.
Look, whether you're a law student, prepping for the bar exam, or just trying to wrap your head around how binding agreements actually work out in the real world, you've probably asked yourself this exact question. Contract law is notoriously dense, but today, we've got the ultimate solution to bypass all that confusion and map everything out perfectly in your brain.
So here's our roadmap for today. 1. The contract memory cheat code. 2. Contract formation with good frogs. 3. Contract defenses using LDU-MUMC. 4. Performance rules via plump cows. And 5. Conditions, breaches, and remedies. We're literally following the natural chronological life cycle of a contract here, from its birth to its potential death. Let's jump in.
Okay, Section 1, the contract memory cheat code. Let's quickly lay down the overarching framework for how these memory tools actually link up to create a unified system. The secret here is that contract law is inherently sequential. So instead of trying to memorize a random jumble of letters and rules, we're going to anchor all our mnemonics to this specific timeline. You start with formation, move to defenses, check performance, and finally deal with breach and remedies. By visualizing this timeline, you'll always know exactly where you are in a legal dispute.
Moving to Section 2, contract formation, or as we like to call it, good frogs. This is step 1. Bringing the actual contract to life.
Good frogs make outstanding apple cider donuts. Okay, I know, it sounds totally ridiculous, but I promise you, this absurd phrase is literally the easiest way to remember the required elements for creating a valid contract. You know what memory experts say, right? The weirder the image, the better it sticks.
So let's break down what that farmyard baking imagery actually stands for. G is governing law, F is formation, M is mutual assent, O is offer, A is acceptance, C is consideration, and D is defenses. The big takeaway here, if you don't have all of these good frogs elements, specifically things like an offer, a valid acceptance, and consideration, well, you don't even have a basic contract to defend in the first place.
Let's zoom in on that G for governing law, because guys, this is the absolute gateway issue you have to solve first. You always need to figure out, is this contract governed by UCC Article 2 for the sale of movable goods, or common law, which handles services, land, and intangibles? And if you've got a mix of both, you just apply the predominant purpose test for those hybrid agreements to see which set of rules takes the wheel.
And looking at the C in our donuts mnemonic, consideration is basically the engine of the contract. It simply means both sides have to exchange something of legal value. It's a bargain for exchange of a benefit or a detriment. You've really got to watch out for tricky traps here, like a pre-existing duty or a promise that's completely illusory. Someone has to give something up, like the forbearance of a legal right, to make the whole thing binding.
All right, Section 3, contract defenses. Enter LDU-MUMC.
Let's see what happens when one party tries to argue the contract was invalid from day one.
Go ahead, say it out loud. LDU-MMC. It sounds like an alien word, I know, but this is your ultimate shield. It holds literally every structural bar to enforcement you could potentially use as a defense.
So whenever a party tries to back out of an agreement, you just run right down this list. Were they under duress? Did they lack capacity, like being a minor? What about undue influence, a mutual mistake, unconscientiousness, misrepresentation, a statute of frauds violation, or just sheer illegality? Running this mental checklist guarantees you won't miss a single defense. Let's talk about that first U on our list, unconscionability. It is a notoriously high bar to clear. To actually void a contract using this defense, you have to prove two things at the exact same time. Procedural unfairness, meaning an unfair surprise or vastly unequal bargaining power, and substantive unfairness, meaning the terms themselves are so overly harsh they literally shock the conscience of the court.
And nestled comfortably right inside LDU-MUMC, under the letter S, is the famous Statute of Frauds. This rule dictates which contracts absolutely have to be in writing to be valid. To remember them, just think my legs. Marriage, contracts taking over a year to perform. Land sales, executor promises, goods over $500, and suretyship, where you agree to pay someone else's debt. Bottom line, if it involves my legs, get it in writing.
Moving right along to Section 4, performance rules, or plump cows. Assuming the contract survived all those defenses, we've hit the execution phase where people actually have to do what they promised. Okay, plump cows always roam down bumpy roads. Again, embrace the weirdness. Keep this farmyard visual locked in your head because it is going to absolutely save you on exam day or in practice when you're evaluating performance standards.
This is your ultimate performance checklist. P checks the standard of performance. Are we talking perfect tender under the UCC or just substantial performance for common law? C looks for conditions. A asks if someone backed out early with anticipatory repudiation. R allocates the risk of loss. D evaluates if supervening events like impossibility trigger a discharge. B identifies the breach, and that final R seeks out the remedies.
Which brings us to Section 5, Conditions, Breaches, and Remedies. This is the final phase, dealing with the direct fallout when performance inevitably goes wrong.
Inside that plump cow's mnemonic, the B for breach is highly critical. You have to classify the failure correctly. Is it a material breach that goes straight to the heart of the agreement, letting you completely stop your own performance and sue right away? Or is it just a minor breach, where you got mostly what you asked for, meaning you still have to perform, but you can sue for the remaining damages later?
Now, for the overachievers out there looking to truly master exactly what subjects these terms fall under, we've got 3 killer submnemonics. For conditions, clever experts can solve wild errors in real work. Helps you remember things like condition precedents and express conditions. For breach, all duties create risks, so manage materially, handles how duties are discharged. And for remedies, many plaintiffs experience anguish, reminds you to calculate expectation damages and mitigated losses. These are your final keys to the kingdom.
So armed with good frogs for formation, LDUMUMSI for defenses, and plump cows for performance and breach, you now have a rigorous, fully structured mental map. You've got everything you need to systematically rip apart any contract from its birth down to its breach. So thinking about all this, what's the very first agreement in your own life you're going to put to the test?